Everything that was in the property of the police department was disclosed to me. I have, what information do you have that there is some other information that I didn't get to review?
I do not have any information, but I might get that information had the file not been redacted.
The file, I redacted the file. Nobody else redacted the file.
I understand that. In the Laurie case, there was a wealth of information revealed. Everything was revealed. I talked to the attorney lawyer. He got everything. Non-redacted.
And you got everything you're entitled to. That's my ruling. So if, you know, the reason I granted you this hearing is because I wanted to make sure that there wasn't something else out there that you are aware of that I didn't get that should have been reviewed. And I agree with you. You may be entitled to things that are out there, but I can't just speculate that they exist unless you have some information that there's something more. I have no reason to believe that the county attorney's office and the police department wouldn't have followed my order and submitted everything to the court for in-camera review as they were told to. And I believe they did. I have no reason to believe that they didn't. So let me, before you go any further, let me ask Attorney Brobst or Attorney Smith whether or not the things that Attorney Kaye is referring to in its attachment list are things that you have, that I gave you, or that you have through some other source.
We had given you, there are some attachments, but not all of those attachments, because at the comments that we had in your chambers, you had asked for more information about what had happened. You just wanted the investigative report, which is what we gave you. We did not give you the complete investigation that was done. This is the summary of what was happening. If you would like that, we can give that to you, but that's not what I actually wanted. This is the report of the investigating officer on the investigation.
I understand that.
Yeah.
Obviously, we've seen this before.
Right.
I think what I'm hearing for the first time, or I misunderstood before, was that there is a larger file that contains some of these attachments that I have not seen. Is that right?
That would be my understanding from looking at this.
There's always a larger file.
Okay. Well, Attorney Kaye, I think you're right about that, and I think if there is a larger file that is attached, I mean, this brings us full circle. I thought that I had everything.
Okay, I apologize. I didn't understand what you were asking.
I want anything and everything that could conceivably be related to Attorney Stahl's credibility, of course, and to his being put on the Laurie list.
And
Come down with the decision.
Attorney Kaye, your request asks for a discovery,
Yes.
the discovery of any protocol. They can only give you the protocol that exists. If you want to take exception to what protocol exists or doesn't exist, that's, I suppose, an argument for another day. But
I would like to see, sorry.
I'll give you the protocol to the extent it exists, and Attorney Smith's not objecting to that.
But I want to see Attorney Heat's protocol. I want to see what their protocol
Well,
is.
if they have one, do you have a protocol, Attorney Smith?
Still following the one that exists now here.
Okay. Attorney Kaye?
I would like to see it right.
All right. So Attorney Smith, if you would provide to Attorney Kaye whatever information you have about the protocol.
We're here at KingCast.net, Courts and Motorsports, and I'm going to explain to you briefly why the state's managing system for the Laurie list, that this is the list of officers who are on a list because they have exculpatory backgrounds. Let's just say that they have done something that places them on a list such that defense counsel may, under certain circumstances, question their credibility. It's the simplest way to explain a Laurie list. And this information helps shape a defense lawyer's ability to work his or her case. Now, in the zealous pursuit of justice, of course, to represent their client zealously within the confines of the law. That is what they're supposed to do. But they can't do that when they don't have all the information before them. Now, what's troubling in this case is that not only did the state fail to produce the Laurie list in the first place, they failed in the second instance to provide all of the information that was in the Laurie list in the first place. So as you look at the scans from my rough draft, I'm going to file a motion to unseal the entire file, because at this point, we have no confidence that anything's being done properly. And that's not Cody Eller's fault, it's not William Hawksley's fault, and it's not Judge Colburn's fault, but she needs to unseal the file. There you go. Well, actually, that's not all. Let me explain this. The rationale that's going on here is that, first off, New Hampshire protects bad cops like there's no tomorrow. It's pathetic. I was talking with Nancy West about this issue. You'll see her in the courtroom as well. She's a reporter largely for the union leader. And we both know that in Florida, for example, the police personnel file, it's open, as it should be. We pay these people to carry a gun and a badge and to make, split-second decisions involving the use of deadly force. So, of course, your personnel file should be open season as far as it goes to performance and the Laurie list issues. But my argument here, and again, I'm not looking to see this guy's file. I don't want to see what his wife needs with respect to his health care or anything like that, or what his children need. No, just his performance issues. That's what should be open season in New Hampshire. And until New Hampshire gets serious about the public's right to know, we're going to have these problems. And my argument is that the public's right to know is a compelling governmental interest that clearly, once a police officer is on a Laurie list, that compelling governmental interest outweighs significantly any compelling governmental interest that the officer has in keeping it private.
That information was accessed, and on what dates it was submitted to the assistant county attorneys involved in the prosecution of this accident. I think that's fair. I think I can speculate that you found out about it shortly after the trial, and I think that's in your pleading.
I don't know what day it was, but whatever the day that I filed that pleading was the day I found out about it.
Okay. Anything else on that point, Attorney Kaye?
No, that was not.
Okay. We get to number 3. That the court order the county attorney's office and the Pelham police to produce all documents relating to Officer Stahl, which they deem non-exculpatory and therefore non-discoverable, to be examined by the court in camera to determine in fact that material is exculpatory. It seems to me that I thought at least that they had already done that, but to the extent that those attachments and that there is more information connected to that investigation, then they certainly got to turn that over to me, and then we'll see where that takes us.
I would ask for any other investigation of Officer Stahl.
Well, right. I mean, that I think is presumed that the personnel file of Officer Stahl, of which I have seen, and it, I told you, and I told you in chambers, that the file that I saw and I got was a fairly large file, and most of it was all commendations for Officer Stahl. There was very little that any person could reasonably argue was negative, okay? All right, then we get to paragraph 4. After review of the material, if produced, the court conduct a hearing as to the admissibility of that evidence concerning Officer Stahl. And that's exactly what Attorney Brooks wants, which has not been released, and that the court deemed appropriate to release that evidence to defense. Listen, I'm going to release to you anything and everything that I believe that you're entitled to. And as is this court's practice and every Superior Court judge's practice in the state, we will maintain a record of everything that comes in, everything that I look at, and what I give you, the order will tell you if there has been things that I haven't given you, and those will be maintained. Represent Mr. Eller going forward on your motion to set aside verdict. I will redact it. If I think that you're entitled to it, I won't redact it, as always. So, okay, lastly, let's just talk about this motion to set aside the verdict. First thing that's got to happen is I've got to get this discovery, I've got to go through it, and if there's going to be any dissemination, we've got to get to that point. Then I presume we will set aside some time for this hearing. I know that there's going to be legal argument first about whether or not it would, any of it would have been admissible, and if I find that it might have been admissible or would have been admissible, then we would move on, I guess, to the second part of the hearing, which would necessitate the state to establish beyond a reasonable doubt that any violation, to the extent that there was a violation, impeded Mr. Eller's ability to have a fair trial. and Attorney Kaye. Presumably you can call witnesses to the stand that you think are relevant to that issue.
Well, it's a bigger part, Your Honor, the legal part. What would I have done as a defense attorney in preparation of my
I know.
case differently had I known about that material?
I understand that. The argument that I'm sure you're going to have with the state at the next hearing, that is part and parcel of the analysis here. And
That's my sister and I, we have been discussing the issue relative to the seal file in and of itself. And I had prepared a motion that I was going to print out and ask you to orally argue it at this point. But in light of the developments today, I want to bolster that motion, and then I would anticipate filing that later this week or the top of next week regarding the whole nature of the seal file itself.
you can file, Mr. King, anything you want to file, and the parties will have an opportunity to respond to it, and you can address it at a future hearing.
Absolutely, thank you, Your Honor.